Hello and welcome to the International Law Podcast, a brand new programme from The Hague. I'm your host, Geraldine Coughlin. Each month I'll be exploring the hive of legal activity here in the international city of peace and justice. Much of it dictates how societies and businesses are run, and yet much goes largely unreported. Today we're at the Peace Palace, cornerstone of The Hague's justice identity. Here, the Permanent Court of Arbitration, the PCA, is where states and big business battle it out. Since 1899, the PCA has produced landmark cases that have made a huge difference to all aspects of society. Judith Levine is Senior Legal Counsel at the PCA. First of all, what is arbitration? Is it legally binding? You don't have a police force. How do you enforce rulings?
Okay, so arbitration is a form of dispute settlement, and essential to arbitration is that the parties consent for their dispute to be resolved by arbitration. That means that they agree to refer their dispute to an arbitrator or a tribunal of 3 or 5 arbitrators to decide it. They decide it according to law, so it's different from mediation, and the result is binding. The fact that they choose the arbitrator means that individuals can be chosen with the relevant experience or knowledge particular to that dispute and those parties.
So do the rulings only apply to states parties, to members of the court, or worldwide?
For the Permanent Court of Arbitration, which is just one institution that administers arbitration, the types of cases that the PCA administer involve states or state-owned entities in combination with other states or private parties. The particular tribunal deciding a dispute before the PCA, its ruling is only binding on the parties before it. So it could be 2 states that have submitted to it, or a state and a non-state entity such as a company.
So that's really significant work. So in that regard, why is the court so silent? It doesn't seem to promote itself an awful lot.
With respect to silence, it might be that for a long period of the 20th century, the PCA was not particularly active, so there wasn't much to be said. And in recent years, say in the last decade, it's seen a sharp increase in its activity. Now, as an institution, we're not silent about the type of work we do. We have a website, annual reports. We report to our 116 member states who participate in the work of the organisation. But where we might be silent in the sense of discreet or confidential is with respect to particular cases, and it's up to the parties to decide how much information can be disclosed. If they want a purely confidential case, we respect that and we're bound by that duty. If they want it to be more open to the public or more transparent, then we'll do what is within the confines of what the parties consent.
Okay, so it's up to them whether or not proceedings are behind closed doors?
Yes, and it's not up to us to talk about it unless the parties have agreed.
One of the most formidable challenges of the 21st century is to strengthen the international legal order. In a globalized world, the peaceful resolution of disputes is crucial. Arbitration is one of our most effective tools for doing just that.
It seems as if the PCA has been gaining momentum over the past couple of years. You've got some quite high-profile cases going on at the moment.
Yes.
Could you give us an example of what you find most interesting?
A couple of examples of interesting or high-profile cases that reflect the variety of cases the PCA handles. Traditionally, we were established in 1899 to handle disputes between states, and an interesting recent example is that between Pakistan and India over the construction of a hydroelectric dam in the Kashmir region, which potentially could affect 80% of Pakistan's water supply. And those 2 countries agreed in a pre-existing treaty to refer the matter to arbitration, and a tribunal found that India could proceed to build the dam, but interestingly had to take account of environmental law principles in the flow of water through that dam, and also set the point at which the gates could open that would affect Pakistan's right to water. Another interesting case that wasn't the traditional country against country dispute, but involved a dispute following a civil war was between the government of Sudan and the Sudanese People's Liberation Movement / Army, involving the Abyei region between North and South Sudan before the referendum on independence. And that was interesting because it was a new type of dispute, intra-state as opposed to international. And the PCA has the flexibility as an organisation to adapt to different types of disputes. And where we've seen the most activity is in disputes between companies and host states over foreign investments under treaties for promotion and protection of investments. And a recent high-profile case was that by the former shareholders of Yukos Oil Company against Russia, which resulted in awards amounting to about $50 billion against Russia for the expropriation of the company.
So really quite significant.
The stakes are high in a lot of our cases. That is true, whether it's natural resources of a country, an oil concession, or contracts for, say, mobile phones, telecommunications services. Some of our cases are on the smaller side if they involve, say, agencies of intergovernmental organisations in a supply contract, but it's fair to say that the stakes are high.
And it's been over a year now since the Netherlands took the Arctic Sunrise case against Russia.
Yes.
And that Greenpeace ship returned here in August. What stage is that case at now?
So the Netherlands filed its memorial, that is its written argument and all its evidence, at the end of August, and the tribunal's procedural order is on our website and sets the timetable. And under that timetable, the next step is for the Russian Federation to tell the tribunal whether or not they will file an argument in response. That is called a counter-memorial. So far, Russia has not been participating in the proceedings. And according to the rules of the tribunal, if Russia doesn't respond to that invitation, then the tribunal will proceed to ask some follow-up questions to the Netherlands, give Russia an opportunity to comment on that, and then decide whether further proceedings may be necessary, such as a hearing.
So what would be the outcome? Wouldn't that be regarded as a kind of a trial in absentia?
In the case is brought under the UN Convention on the Law of the Sea, and that treaty specifically envisages a situation where a state doesn't appear or fails to defend its case. And the treaty provides that non-appearance by a state is no bar to continuing with the proceedings, and as long as the tribunal is satisfied that it has the power over the dispute, called jurisdiction, and that the claim is made out in fact or law. Now, the Russian Federation is copied on all correspondence, is sent copies of the transcripts of any hearing, and is always open to the Russian Federation to participate if they so choose.
Okay, so if they so choose, it would be better for their reputation if they would join in?
What their reputation is isn't something I can comment on, but it is perceived that, I think participation by both parties, getting to hear the arguments of both parties, is something that others have said is for the better for the international dispute settlement mechanisms within that treaty, but it is up to that state as a sovereign state to choose to exercise its rights.
The PCA hosts guest tribunals for organisations like the International Chamber of Commerce. Mm-hmm. How does that work?
So the PCA has a number of cooperation agreements with other international courts and tribunals and institutions. We use the facilities here at the Peace Palace for our hearings, but in fact only about a third of the almost 100 cases that we're currently administering have hearings that take place in The Hague. Part of arbitration's appeal is its flexibility, and that might mean that parties choose to have their proceedings held anywhere else in the world. So we sometimes use the facilities of other organisations abroad, such as in Washington, D.C. at the World Bank's International Centre for the Settlement of Investment Disputes, or the ICC facilities in Paris. And by the same token, those institutions sometimes come to use the Peace Palace themselves. Now, it's a user pays principle. In PCA cases, the user doesn't pay for the Peace Palace. And because it's in the Netherlands under our host country agreement, parties and participants have certain privileges and immunities, such as it's easy for witnesses to get visas to participate in hearings here. And we have mirrored that system with some of our member states by entering host country agreements abroad, such as with Costa Rica, Mauritius and Singapore, all of which we've held hearings in those countries.
The PCA's cases are either, as you say, between states or between big business and states. But taking a case to the Permanent Court of Arbitration obviously costs a lot of money. Where do parties get their cash from?
That's a good question, and arbitration can be a costly process. In the scheme of those costs, the biggest item is the party's own lawyers, and the arbitrator's costs or the institution costs usually make up about 10% of the total costs. It's true that bringing a matter to arbitration can be expensive, but if you consider that the alternative is war, that's a more expensive scenario than a peaceful resolution of disputes. For companies, part of the cost of doing business globally is enforcing contract rights and treaty rights, so it is budgeted for from them. For developing countries who are member states of the PCA, the member states of the PCA have set up a kind of legal aid for developing countries in the form of a financial assistance fund. So the ABA arbitration involving Sudan that I mentioned, the parties were able to access around €500,000 from that fund to help defray the costs of arbitration. The last thing anybody wants is the costs of arbitration to get in the way of a peaceful settlement of a dispute. In some other cases, we know sometimes lawyers will act pro bono, as they did for the Southern Party in the ABA arbitration, and increasingly a hot topic in international dispute resolution at the moment is the use of third-party funders who come in and take a chance that a claim may be successful, so they help fund the claim with the expectation that they may receive something in return at the end of the day with a damages award.
And finally, Judith, how do you envisage the role of the PCA evolving? Is it going to make much difference in the near future to the man in the street?
Well, how to envisage the role of the PCA evolving? I think one trend that we've seen in the last century, and especially in this recent period of increased activity, is that international law is no longer just the domain of states, but can affect individuals, companies, NGOs, and these are becoming players in the disputes before us, either by being claimants themselves under a treaty brought by an individual or a company, or through non-governmental organisations who may seek to make submissions before a tribunal. So the rise of non-state actors is a trend. Another trend that we're seeing is the intersection of energy disputes and environmental matters. So as for the man or woman in the street, how does our work affect them? Well, if they're a citizen of a country who's in dispute with another country over its borders or natural resources, that can affect their wealth or security. It may be that as individual business people, they could have a claim or be shareholders of a company that has a claim. As students, as our cases become more public when the parties consent, there is a body of jurisprudence, while not binding, it's still influential in the development of law.
Many thanks to Judith Levine, Senior Legal Counsel at the PCA. Please join us for our next podcast on human rights at sea. You can listen at gcclaw.nl. I'm Geraldine Coughlin of GCC Law and Media. Follow us on Twitter and Facebook. This programme was produced by Richard Walker.